Judge Torres delivered shocking verdict in Ripple case. Ripple won a significant victory, as Justice of the Peace Sarah Net Byrne rejected the requirements of the U.S. Securities and Exchange Commission, SEC, on attorney-client confidentiality in relation to internal electronic documents to William Hinman's speech. Welcome to the Finance Up channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. The documents must be submitted, she concluded. Moreover, the judge accused the commission of hypocrisy, because it claimed that the speech had nothing to do with cryptocurrency regulation, while simultaneously claiming that Hinman was receiving legal advice from an SEC advisor. Judge Net Byrne added that the agency had taken its judicial position to achieve its goal. Quote, hypocrisy in arguments to the court, on the one hand, that it has nothing to do with the market's understanding of how and whether the SEC will regulate cryptocurrency, and on the other hand, that Hinman applied and received legal advice from an SEC advisor when drafting his speech suggests that the SEC takes its position in the process to achieve the desired goal, and not because of loyalty to the law. The Securities and Exchange Commission wanted to use the principle of attorney-client privilege to protect internal documents related to the infamous speech about Ethereum delivered by a former high-ranking official of the agency, William Hinman. Initially, the plaintiff tried to defend the privilege of the deliberative process, but in January the agency prevented this attempt. The court determined that collecting facts from third parties is not a privileged activity. At the end of April, the Securities and Exchange Commission made another attempt to hide Hinman's emails, claiming the confidentiality of the lawyer and client. The plaintiff argued that the documents in question reflect confidential information, adding that Hinman should have been recognized as a client of SEC lawyers who gave him legal advice. The Securities and Exchange Commission also stressed that the drafting of the speech would not be available to him as a private person. However, the defendants argued that Hinman was not a client of the agency's lawyers. The evidence establishes that the predominant purpose of the communications was not to provide legal advice, the court said. Well-known lawyer James K. Phelan, who closely follows the progress of the case, called this decision a blow to the body. Gabriel Shapiro, general counsel of Delphi Digital, called it a big tactical victory for Ripple on Twitter. Do not rush to rejoice too much, because the next step of the SEC will be to appeal the court's decision to a higher instance, Judge Torres. Lawyer John Deaton believes that within 30 days we will see an appeal from the SEC and, accordingly, an objection from Ripple's legal team. Earlier, the SEC requested that the court allow 1. The revision of the Securities and Exchange Commission letter, 2. The revision of the defendant's letter, and 3. The sealing of some physical evidence to both letters. Judge Torres made the following decisions. She allowed the amendments proposed by the SEC because they are highly specialized, and now the Commission can edit certain parts of its objection to Amici's participation in the case. However, Judge Torres issued an ambiguous decision in response to the SEC's request to seal and edit the physical evidence in his letter of objection. Accordingly, the court partially satisfies and partially rejects the request of the Securities and Exchange Commission to seal and edit the exhibits to the letters, Judge Torres ruled. Judge Torres has granted in part and denied in part the parties' requests to seal documents in connection with the amici motion to participate in the Daubert proceedings. Proposed redactions are due by July 15, 2022. This is due to the fact that Ripple's defendants claimed that the SEC took an extreme position regarding expert reports. In a recent letter addressed to Judge Annalisa Torres, they claim that the plaintiff is trying to silence any substantial criticism. Quote, Ripple also said in a statement that the SEC took the unprecedented step of requiring that Ripple's claims against 3 SEC experts be filed under seal before the judge's decision on whether to classify the opinion of the 4th expert, Patrick B. Doody, who, according to the SEC, was subjected to threats and harassment. Quote, this means that the public can see the reports of expert witnesses, with the exception of a small part of them, which in one way or another was directly related to the harassment directed at the expert, commented Jeremy Hogan, lawyer for Hogan & Hogan. He also called Judge Torres' recent decision regarding the party's request to seal the documents a good result, since the public can see the reports of expert witnesses, with the exception of a small part of them. This was somehow directly related to the persecution of the expert. Quote, "Yes, this is a good outcome." Patrick Doty's involvement in this case became known when XRP holders who received amicus status in the lawsuit tried to file a petition challenging his expert opinion. At the end of May, crypto law founder John Deaton filed a motion to ask a judge to allow him to file a briefing on behalf of tens of thousands of XRP holders. In recent court documents, the SEC argued that disclosing information about the expert's findings in the public domain could spark discussion and lead to even more harassment and intimidation. Quote, "The SEC has filed its response to the Ripple defendants' request for expedited briefing regarding the disputed SEC sealing requests in connection with the upcoming Daubert challenges." In other updates shared by James K. Phelan, the Securities and Exchange Commission filed a response to the defendants' letter demanding an expedited briefing. The SEC stated that the schedule of expedited briefings proposed by Ripple was not brought to the agency's attention, and the two parties did not meet or confer to discuss the briefing schedule. The agency noted that it did not object to Ripple's request. The SEC has filed its response to the Ripple defendants' request for expedited briefing regarding the disputed SEC sealing requests in connection with the upcoming Daubert challenges. Ripple and the SEC are arguing over expert opinions. According to the defendants, the SEC takes an extreme position that the names of its experts and any significant criticism of their reports should be hidden from the public. An expedited briefing on this issue has been requested. After the request to close information about Expert 1, the SEC also announced that the sealing should be extended to 3 other experts. The Commission not only wants their names and related information to remain undisclosed, it also wants any movement on the substance of their reports to be hidden. This happens until the movement around the first expert is resolved. In the U.S. judicial system, there are expert witness statements in accordance with Rule 702 of the Federal Rules of Evidence, which was changed after the Daubert case, ed. Ripple stated that the purpose of Daubert's petition is to question the reliability and admissibility of the expert opinion. The request of the Securities and Exchange Commission actually means that the entire petition of the 4 experts must be filed classified. Ripple criticized the SEC's actions for contradicting the public's right to access important materials. The SEC's attempt to suppress criticism of its expert opinions is particularly egregious, considering that none of the SEC's expert reports are likely to contain SEC confidential information. The only confidential information is internal information about Ripple itself and third parties. Quote, "The current price of XRP for today you can see yourself on the screens, and the trading volume for 24 hours is $1,294,436,065 US. We are updating our XRP price in US dollars in real time. XRP has dropped 4.08% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments." That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.